Earlier, we mentioned Walmart's big win in a class action lawsuit in Washington. Now let's bring in attorney Seth Berenzweig, founder and managing partner of Berenzweig Leonard. He's been recognized in honorary lists of legal elite and super lawyer in the Washington, D.C. region, and he regularly handles government contracts and labor and employment law. He joins us from our Washington bureau. Mr. Berenzweig, welcome to Bottom Line. Thanks so much for coming on.
My pleasure. Good afternoon.
Sir, how significant is Wal-Mart v. Dukes in the annals of American justice?
This is one of the most important business law cases in decades that's been decided by the Supreme Court. This is a landmark victory for Walmart, and it is an absolutely devastating defeat for the plaintiffs. The Supreme Court has fundamentally changed the face of employment cases and discrimination with its landmark decision today. Walmart avoids a major class action lawsuit from moving forward, which would have affected between 1 million and 1.5 million of its employees, posing potentially billions of dollars in damages. And for the plaintiffs who have been fighting this legally for 12 years, it takes that class action mechanism and it throws it out completely.
Yeah.
So it is a major change and a big landmark decision.
Mr. Berenzweig, was I correct when I heard earlier today that you predicted that the outcome was going to be this way? Is that right?
That's correct. I predicted that because I believed, and it just turned out to be, fortunately for me anyway, but not fortunately for the plaintiffs, a correct prediction, that you can't have 6 plaintiffs accurately representing 1.5 million employees. As the Supreme Court concluded today, it lacks what's called the commonality element of the class action lawsuit part of the federal rules.
Right.
And as a result of that, that was just fundamentally, in the court's opinion, incorrect. In a sharply divided vote, which was essentially 5-4, it was ruled that it couldn't even be remanded back down.
Yeah.
So if these individuals are going to move forward, they have to do so individually.
Well, Justice Antonin Scalia wrote for the majority, and he wrote the following: even if every single one of those anecdotes is true, and anecdotes he was referring to about bias or discrimination, he said that would not demonstrate that the entire company operates under a general policy of discrimination. Does this mean that class action lawsuits, as we've come to know them, are now obsolete?
They're not obsolete, but they're very much narrowed down. This was a major development where class action lawsuits, particularly against large corporations, are going to be narrowed down in scope. Because what happens now is that a history of class action litigation involving anecdotal evidence, statistical evidence, general alleged cultures of inherent bias are going to go by the wayside, and the evidence, the requirements are going to be fundamentally changed. It is a major change on the face of discrimination litigation throughout the United States.
Okay, so in this argument, then, the burden of proof here obviously was on the plaintiffs. So there's burden of proof, and there's being burdened with trying to find the burden of proof here going forward.
Well, that was a major critical element because the plaintiffs' lawyers made a decision that they wanted to have 6 people try to represent the interests of 1.5 million, up to 1.5 million individuals. And as Justice Scalia wrote for the majority, that's just untenable. There's no glue of commonality to hold this together. It was a sharply divided vote. Justice Kennedy was the swing vote in this. So you can see that by a razor-thin margin, Walmart got a landmark victory today. And you can see how important it is as to the makeup of the Supreme Court moving forward.
Right.
It's a fundamental change in how that kind of litigation is moving forward throughout the United States.
Mr. Berenzweig, how will today's decision affect how companies now defend themselves in discrimination lawsuits?
Well, that's a great question, and I think that corporate America needs to look at that very carefully. They have to understand that the evidentiary standard is more specific. There's going to be a laser focus tunneled right into the company. They have to maintain corporate records, understand that the evidence is going to be tunneled more focused, more specifically against managers, against supervisors, emails, all those kinds of correspondence that have to show animus. So they need more training and compliance, and help people understand that this kind of evidence is really going to hit the bottom line for these cases moving forward.
Well, I don't mean to be flippant, but it just comes to mind because, you know, the phrase is all politics is local. It would seem now in these types of cases, all discrimination is local. It's at the local level and not painting a company with a broad brush. Do I have that right? I don't mean to be flippant about it, but is that about right?
Well, I agree with that and that was the problem with the narrow majority of the Supreme Court. It was too broad of a brush to paint because they were talking about a sociologist and a statistician talking about a broad brush of an environment of discrimination. And the court said you have to get more specific. Those days are over.
Yeah.
And inadvertent discrimination is also going to be dramatically changed. This is one of the most significant Supreme Court decisions in decades.
Last 30 seconds. What's the recourse for employees who feel that they have a prima facie case of bias or discrimination going forward?
In this case, they can no longer move forward in a class action context. They have to take a step back, having lost 12 years of their lives in the legal realm. They can proceed individually.
Yeah.
They can file individual discrimination claims against Walmart. Many will do so, but many will drop out. And that will be the next step moving forward.
Could I ask you in about 20 seconds, is this the end of the
Sure.
legal fight? Aren't there more claims, discrimination claims yet to be filed?
There are more discrimination claims, and there are claims that are alive in this case, too. It's just that it's instead of being a huge monolith of a multi-billion-dollar risk for Walmart,
right,
it's going to be dwindled down, not only in terms of individual claims, but a lot of these claimants are going to just peel off because I think that they've had enough, and therefore this is a landmark victory for Walmart and for large companies in corporate America.
Seth Berenzweig, he's an attorney and founding and managing partner of Berenzweig Leonard from Washington. Always a pleasure to have you on. Thanks so much for your perspective. We appreciate it.
Great seeing you.